Good afternoon. Let's get started. My name is Christian Burset, Associate Professor of Law here at Notre Dame. Welcome to the first event in our Global Spotlight Lecture Series. This series highlights our law school's new Global Lawyering Initiative, which we launched last year. The goal of this initiative is to establish Notre Dame Law School as the leading American law school for global engagement and global opportunities for students, faculty, and staff, and to support collaborative teaching and research between our faculty and scholars abroad. The initiative capitalizes on the university's network of global campuses and centers around the world, including London, where the law school has run the London Law Program for more than 50 years. It is the only year-long study abroad program approved by the American Bar Association. As part of the Global Lawyering Initiative, we are engaging in a major reinvestment in that program. It has several aspects. First, we're overhauling the curriculum to better meet the needs of our students and to take advantage of all that London has to offer young lawyers in training. Second, we want to strengthen ties between teaching and research programs in London and here on the home campus. And finally, our reinvestment in London means that we are appointing first-class scholars from the UK and Europe to teach in that program. Dr. Matthew Dyson is one of those faculty members. He's an associate professor of law and a fellow of Corpus Christi College, Oxford. In addition to his academic work, he's an associate member of the 6 KBW College Hill Chambers, a leading set of barristers' chambers in London. We're also joined today by John Murphy, professor of law at Lancaster University in the UK. He's also been a visiting professor in Canada, Singapore, Hong Kong, and Australia. Our third panelist is Marta Pantaleón Díaz, who's completing her PhD in law at the Universidad Autónoma de Madrid. She's already published some of her very interesting research in both Spanish and English. Two technical notes before we get started. First, we'll have time for questions once the speakers have finished. You'll need to submit questions using the Q&A function for this webinar. Second, if you encounter any technical issues, please let us know using that same function. Finally, I'd like to acknowledge the people who have conceived of this series and have made it possible. First, Professor Michael Addo, Director of our London Law Program, Professor Paul Miller, the Associate Dean for International and Graduate Programs here at the Law School, Dr. Felicia Caponigri, Acting Director of International and Graduate Programs, and Jean-Marc Brissot, the Graduate Programs Manager. And with that, I'll hand it off to Professor Dyson.
Thank you very much. So what does intention mean? What does recklessness mean? What does negligence mean? And what does strict liability mean? Well, there's many ways we could answer those questions. Some of them are just single issue answers. So we could find a doctrinal test. We could have a normative description, or we could have a practical way to find fault, the evidence, the procedure. Some of the ways we could answer those questions are relative. So we could talk about the role of fault compared to another form of fault. So intention compared to recklessness. We could talk about the role of fault in generating a larger outcome, like liability. We could talk about the role of fault in relation to other parts of generating that outcome, like capacity, causation, or a recognized form of harm. Or finally, we could compare between one thing called fault and another thing called fault. So intention in criminal law and intention in tort law. This seminar will be looking at the idea of fault and be asking some difficult questions and looking at some interesting doctrine. You will hear from me about some snippets of the development of English law and some comparisons to a few other jurisdictions. You'll hear from John Murphy about fault in one particular context, the economic torts, and how they're one of the rare and interesting places where Anglo-American tort law engages with fault elements other than negligence on any scale. And you will then hear from Marta Pantaleón Díaz with some comparisons of civil law and criminal law from a civil law tradition. Now, we'd like to give you a series of examples about how all these issues are interesting and how surprisingly, some of their answers might not be what you think, and we might not have the answers we think we should. As you'll probably imagine, we have some clarity on some individual issues, but it gets a bit more difficult when we start comparing one issue to another. Each time the ambiguities in one place are multiplied when they're compared with another. And obviously, in the time we have, we cannot give you all the possible information we'd like. believe me when I tell you, there are pages, hundreds of pages, hundreds of thousands of words written about this kind of topic by at least some of us, and there are probably more written by even more people who we don't have time to talk about. What we're trying to do is just to give you an overview about why some of these ideas are so interesting and why it might be useful for you as you're doing the kinds of lawyering you want to do, to think about perhaps some other perspectives and some doctrine and difficult questions like these. So my examples are going to be drawn from civil and criminal law from around 1850. Now that's a date marked in England by certain procedural and then substantive changes. There's quite literally lots of things we could be talking about, but what I'd like to focus on now is a brief introduction to criminal law and tort law in this kind of question, and then I'll give you a few specific examples. So the offences of criminal law have, for centuries, been divided into groups of offences such as things like offence against the person, against property, and recently sexual offences. Criminal law has not really organised itself around fault elements required. We don't talk about the intentional crimes, the reckless crimes. Very occasionally we have done, for instance, in the rules relating to intoxication, but those rules are remarkably unimpressive, at least in England, and I don't really think they provide us much evidence of a system like that working. We do sometimes talk about strict liability crimes. By comparison, tort law has grown into compartments, at least very loosely, where we tend to talk about the fault element as being significant. But since there are so many individual torts, the pattern doesn't really hold very well. And in particular, tort law features large sections, at least in England, but even more so in a number of other civilian jurisdictions, of strict liability. The French are particularly famous for it, and in some areas of law, particularly in the Anglo-American tradition, the US has gone even further than we have in England. The obvious example being product liability initially, and then ultra-hazardous activities after that. So tort law has definitely not organised itself around fault elements, but we might use that language a little more there. The intentional torts are one such example, but even there in tort law, there's a bit of uncertainty. Do we mean intention merely in the sense of a voluntary act, or do we mean intention as regards the result of the conduct? And typically we only mean a voluntary act, and later on there is some sort of greater harm that happens which you don't have to intend. But again, there is variation in our usage. So in the period I'm describing from 1850, criminal law developed out of impressionistic or moralistic conceptions of fault in the form of malice or wickedness, and accepted strict liability. But it did not develop widespread negligence-based liability, arguably until maybe only a few years ago, and even then it's not in the traditional areas of criminal law, it's typically in regulatory and other forms of offences. So English criminal law very rarely uses negligence at its traditional core. That's in contrast to some other legal systems, depending on exactly what we define as negligence, where it is more common. Now, notably, English criminal law does use strict liability inside the core of criminal law. Even its offence of murder involves, at least potentially, strict liability. You don't have to intend death, you only have to intend serious bodily harm and kill. Now, to any continental civilian lawyer, the idea of strict liability on the scale that we have it is troubling and it's very surprising. But for us, we're completely used to it. Ultimately, criminal law decided that recklessness would be a different fault element to intention. Now, here we go. Intention we're going to talk about in a moment, so too recklessness. But just for this purpose, let me say intention, some sense that it was your purpose that the outcome happen, and recklessness, some sort of awareness of the risk of that happening and going on unreasonably to take that risk. Now, English law separated that out as a separate form of fault, but it only really did so probably around the 1920s, 1930s, and the process wasn't completed until the 1970s. So it's a relatively new addition to our law. So we ended up with intention and recklessness as our primary volition expressing fault elements. We did accept strict liability inside criminal law. The process started somewhere in the early 1800s. There were a few other separate examples, but somewhere in the early 1800s, and it grew out of public welfare offences, the kinds of things related to not traditional criminal law, like murder or theft, but along the lines of adulterated bread or beer. So you wouldn't need to know that the bread you were selling had something that wasn't supposed to be inside it, you would just be liable for selling bread that had it inside. This growth in strict liability is really interesting in English law for reasons I'm going to come into, but it's become fully established. And we're not even entirely sure how many offences we have in England, but we probably have at least half of them involving some element of strict liability, where strict liability for England at least, and I think, well, at least this is the definition, I think that will be recognised in the US as well, where strict liability means there is at least one physical component of the crime which does not require a mental component. So there is some element of what you did that you don't have to have fault about. That's just a very brief introduction to the development of fault in criminal law. Now in tort law. So the classic example that you're probably familiar with is the idea of negligence. This developed as failure to take reasonable care in the circumstances somewhere between the 1860s and 1930s. The idea of not taking care appropriate for the circumstances was known to English law before that, and it had arisen in a number of little places. But as a freestanding ground generating liability, it was held back by a number of procedural reasons. It really started to shine somewhere just into the second half of the 19th century. And as we probably know, it has become remarkably dominant since then, such that around 90% of personal injury actions in England turn on negligence, and they are by far the largest proportion of tort claims. So that negligence standard has been quite remarkable, both because it has been so stable. We haven't really changed what failing to take reasonable care means since it was created, but also because it became the emblem of what negligence needed to be. So we had a few examples where other torts started to look a little bit like they might be absorbed by negligence, and breach of statutory duty is one of those, well, at least in part, under American influence. And we attempted that for a little under 20 years, but decided that it didn't work because sometimes breach of statutory duty would not be expressed in terms of a duty to take care. And if it wasn't in terms of a duty to take care, it couldn't fit within negligence. The classic example was factories legislation requiring that machinery be securely fenced. This wasn't a duty to take care that machinery was securely fenced. It was a duty to make sure that this machinery was securely fenced. And as such, though it was attempted to be fitted within negligence, it was pushed out again a few years later. This happened between 1934 and 1949. So that standard of taking reasonable care became very emblematic of negligence and represents the flexibility which drives negligence dominance inside tort law. So we do still have some fault elements in other torts other than negligence, of course. We certainly have strict liability regardless of whether there is fault, but we do have malice, for instance, which has a difficult meaning, and John is very much the expert on that, and you'll be hearing from him soon. We did attempt an idea of a prima facie tort theory, again, something discussed not exactly, essentially very early days by Oliver Wendell Holmes Jr. and then Frederick Pollock, and two judges, Lord Blackburn and Lord Justice Bowen, who argued that there could be a possibility of saying that wherever you intend to cause harm and you do cause harm, that there should be a tort, all other things being equal. But this was shot down spectacularly in a case called Allen and Flood in the House of Lords in 1898, and we haven't really looked back. Intentionally inflicting harm is on its own no ground for liability. You would have to establish some reason why tort law itself would generate a duty or would generate some sort of underlying right that's been infringed. So that's just a very brief pattern in the last 150 odd years of criminal law and tort law. Now for some tricky questions, which I must admit, many of them don't entirely have answers. So intention, right? Something we should be familiar with, you'd have imagined. Do you find it interesting that most legal systems don't have a very precise definition of intention? And certainly speaking from English example, we have a definition, but it's different for criminal law than it is in tort law. And the definition we have relies extensively on what the fact finder is willing to find. So to give you an expression of this, there isn't a single agreed definition in criminal law. The easiest we come up with is something that a theorist called Anthony Duff gave as an example, which is the failure test. Would you think you had failed if this thing wasn't achieved? Well, okay, that seems to make sense, but it only covers things that were directly your purpose. We don't give a jury any other information. The standard instruction to a jury in a criminal case, or to a magistrate in the 95% of cases that don't get past the magistrate's court, is, are you sure that D intended to whatever it is? Now that's not very detailed. It just asks, are you sure that, and uses the word intend. And then we have a quote unquote golden rule, as Lord Bridge said in a case in the 1980s, that we don't give juries any further information because it is a word that they should understand naturally. It's a word that we should all be able to understand. In the very rare circumstances where that kind of information isn't enough, that you can't just ask them to do something, to intend and to find out what it means, we do have a further definition to give, and we call this an oblique intention direction. And it's something that students every year struggle with. And it's a little unfair because in practice, it almost never gets used. I will meet practitioners who never see it used in the courts. And it goes along the lines of this. If you cannot, because of the nature of the facts you're investigating, really say that it was about a purpose, then a jury may be told, they don't have to be told, that they have a choice. If they find that the defendant foresaw something as virtually certain, and it was virtually certain, then they can find that that is equivalent to intention. Now, it doesn't say that foreseeing a virtual certainty is equivalent to intention. The jury are given what one theorist, Jeremy Horder, has said is moral elbow room to decide whether foreseeing a virtual certainty was in fact equivalent to intention. This does not get used often, as I said, but notice it's also somewhat blurry. It's not telling you actually whether foreseeing something is virtually certain and going on to take the risk is intention, nor is it explaining to you what the difference between purpose and likelihood of outcome is. And for some continental criminal theorists, it would be strange because it takes up most of the space of what you might call indirect intention. This is not where your purpose is the thing that happened, but where the thing that happened is a necessary part of what your purpose is. The classic example being pulling out a gun to shoot somebody out of a window, and the bullet will pass through the window, break the glass, and hit the person down in the street. Now, you don't actually care about the window. If you were asked the Duff failure test, would you think you'd failed if you didn't break the window? Your response would be, nope, I'm quite happy to do that. And as such, you might say, well, you didn't intend to break the window, but you can't kill the person on the other side of the window without breaking it. So it would be a necessary component. And some legal systems include such indirect intentions. We cover some of that ground with an oblique intention direction when we give it. Now, interestingly, English tort law has never developed anything like an oblique intention direction. We do not have a test based on virtual certainty, likelihood, or anything, or knowledge of a chance in developing what intention is. Funnily enough, English tort law occasionally even seems to include foresight of a possibility as counting as intention. And at other times, particularly in the economic torts, gives very, very specific instructions about what intention might be. Of course, some of you are already fidgeting in your streets, getting excited because you know about Garrett and Daly from 1955. So in the US, there is case law saying that pulling a chair away before someone sits down and deciding whether that's a battery could be decided on the basis that you intend to make someone fall so long as you know there is a near certainty that it's going to happen. Now, on its facts, it's difficult to understand why that case needed that definition, because on the facts it looked quite obvious. But even so, it's interesting that in the US in 1955, case law was developed to do the very thing that English tort law has never felt the need to do. So here we can already see that basically neither English criminal law nor English tort law properly defines what intention is as a general rule. English tort law has specific rules for what intention might be in different torts, and even then is not very specific about its relationship with purpose and certainty. And we've never developed anything like the criminal law developed, even though both could be triggered on the same facts. Now, I already mentioned that English criminal law developed recklessness, just like you're familiar with recklessness in the US. The definition under the Model Penal Code is pretty similar to the one we use in England, foreseeing a risk and going on unreasonably to take it. In fact, the Model Penal Code talks about disregarding a risk, which might be interpreted in a slightly different way potentially, but let's assume they're similar for the moment. So English law decided that intention wouldn't include deliberate risk-taking any longer. It did, probably in the 19th century, because they didn't draw a distinction between having something as your purpose and demonstrating a willingness to take the risk of it happening. But since the early 20th century, English law has drawn that distinction. But English tort law hasn't. Only English criminal law has. And that's interesting and in some ways surprising. Sometimes tort cases do mention recklessness. And sometimes it comes up in issues like transferred malice, where you intend to harm one person, but the harm befalls somebody else. Often, for exam purposes, your best friend, who you wouldn't normally want to hurt. So it's interesting that recklessness and intention have taken this two-part form to the development of English law. Whereas in some civilian systems, in fact, many civilian systems, dolus eventualis would have been used instead of recklessness. That's instead of direct intention, your purpose, instead of indirect intention, a necessary part of your purpose, you would be liable as having intended, where you foresee something as a significant risk and demonstrate a willingness to accept that risk. Now, the precise definition might vary from system to system, but that's a starting point. So for what we would mark out as recklessness, many legal systems mark out as intention. What's the difference? Is there a labeling difference? Does it matter? And notice that the major difference between recklessness and dolus eventualis is that in the English version, you don't have to demonstrate anything about your willingness to take the risk, only that you foresaw it and took it. You could have foreseen it and thought it wouldn't happen. You could have foreseen it and forgotten about it. You could have foreseen it and decided, yes, you don't care if it happens. But nonetheless, you're liable merely for foreseeing it. There's difficult questions about how you demonstrate someone's willingness to take a risk unless they've helpfully written a diary. I'd like to turn away from recklessness now and to consider strict liability, because here are some particularly surprising differences between tort law and criminal law. I've already mentioned the definition of strict liability in criminal law, that a person does not need to have fault about at least one physical element of the crime. And that's the definition, and the same under the Model Penal Code, though the Model Penal Code essentially restricts this to non-serious crimes, whereas in English law, as I already mentioned, it can apply to very serious crimes. Tort law has a completely different definition of strict liability. In strict liability terms in tort law, fault does not need to be proven for the claim to be established. So sometimes this is expressed as liability regardless of fault. Sometimes there are difficult questions about whether there is then a defense where the defendant can show he or she was not at fault. And there are sometimes other difficult questions. But essentially, if you think the claim does not need fault to be established, that's not saying one part of the claim doesn't need it. It says the claim as a whole. So there are two fundamentally different definitions of strict liability in criminal law and in tort law. Now, there are many reasons why this has happened, but one of the interesting consequences of the early adoption of criminal law using a strict liability model, when the definition wasn't so certain, is that we haven't developed a separate regulatory jurisdiction in England. We don't have something that isn't criminal law where you punish. We don't have a group of regulatory offences, as many other legal systems, particularly on the continent, do. So we have a choice of criminal law or not criminal law, and we might use some sort of minor administrative fine, but we don't have a group of offences otherwise. It makes some of our areas of law a little bit strange. So some parking offences and some road traffic offences are criminal in some ways, but not criminal for others. For instance, whether you have to disclose them after a certain amount of time and what the nature of the penalties are. But because strict liability became so established in the criminal law, we didn't develop a need for something else like a regulatory jurisdiction. It also interestingly means that because strict liability was so adaptable, because it could be one or more elements that didn't have fault, we didn't start using negligence as a minimum requirement into other areas of law. Think back to what I mentioned a little bit about 10-15 minutes ago, and you'd realize that all of this started to happen in the very early 1800s. In fact, it was interesting that it was only a few years after we formally decided that you had to have mens rea normally for a crime, that we then decided there would be exceptions to it. This was very early in the development of what we might call the modern criminal law. In this kind of period, defendants weren't allowed counsel, and they couldn't give evidence on their own part in their own defense. Indeed, nor could you in civil cases until the mid to end of the 19th century, because you would be financially interested in the outcome, so you couldn't be trusted. So a lot of these issues are bound up with how procedure and evidence reached decision makers. A lot of these issues are much more complicated than they would appear today. But the basic message that I'm trying to draw out is a lot of these, the way these different fault elements interact with each other and compare across civil law and criminal law, tells you something about what's really happening in what's driving criminal law and civil law forward. These issues are closely and tightly interrelated. One of the other things that I wanted to mention was motive. So we've decided from very early on in the criminal law, around the same time we were deciding that mens rea was necessary, that motive wouldn't normally be relevant to criminal law. That sounds obvious. When you talk about the mens rea elements, intention, recklessness, and so on, we don't talk about motive. But what we've done is push those elements somewhere else. You might be thinking, where? Well, what about defenses? Many of our defenses then bring back into play issues which otherwise would have been described as motive. Self-defense is the obvious example. Did you punch the person? Yes. Did you mean to? Yes. Well, okay, then you're liable. No, you would respond, I'm not liable because the reason why I did it makes it okay. Indeed, in some theorists' minds, it means that there was no unlawful conduct and there was no culpability, even though you've demonstrated the physical components and the fault elements. So there you're seeing something that looks a lot like motive taking effect at the level of a defense. Now, tort law has a very different pattern for how its defenses work, but in some of its instances, particularly in the economic torts, in deciding what is malice, it has taken into account things which would otherwise be described as motive. For instance, that you had no lawful reason or just excuse for your behavior. It takes account of why you're doing something to decide whether there was intrinsically a wrong that might need remedying. So notice that tort law has been including elements that might otherwise be described as a motive in an earlier stage than criminal law would have been doing. And that's partly because it's kept hold of the term malice, which criminal law in England got rid of somewhere around the 1870s. And since then, it just means intention or recklessness. We still see it because many of our offences date from that period and we haven't updated them since. But whenever we see the word malice or maliciously, we simply read the words intention or intentionally or recklessly. One small trick there is we haven't really understood what the difference is between indifference and motive. Very occasionally, we still see people raising the issue of indifference, both in tort law and in criminal law, as a way to express greater moral disapprobation of a person's conduct. Particularly, we saw this in defining recklessness. There was a period when recklessness was objective. You were reckless where a reasonable person would have foreseen the risk, whether you did or not. There is a very difficult question about the role of indifference in deciding purpose liability, and we haven't answered it. Now, I've taken up about as much time as I have with you. What I wanted to do is highlight how difficult some of these fault issues are and how there are very important questions we can answer, even if we can't fully answer them. It's really important to understand the fundamental lesson of what limits you're putting in your own reasoning. Do you stop deciding what intention is once you reach the edge of criminal law? That might sound very appealing and easy. But many of our judges one day might be deciding a civil case and the next day deciding a criminal case. Can they compartmentalize the idea of intention just so easily by whether it's Monday or Tuesday? Should they have to? One of the ways that you're forced to break down those kinds of categories is procedures that interact across criminal and civil law. Now, for an American audience and for an English audience, we are familiar perhaps with something called a compensation order, which is when a criminal court has determined that you've caused harm by your crime and you should compensate the person who you caused harm to, sometimes known as a restitution order in the US. That seems easy enough, and it's an order of the criminal court. But for most jurisdictions, at least on the continent of Europe and in many other countries as well, they would instead not use a criminal order, but they would use tort law. A criminal judge would swap his hats or her hats and use tort law to decide compensation. In that case, the criminal judge would be forced to look at what the rules are in criminal law and tort law and make comparisons, even if he or she didn't articulate them. That kind of procedure forcing you to compare is something that in practice very many legal systems are familiar with, but the Anglo-American legal system is not. Now, there are many other ways that you might ask these questions. You might just be a student happening to study criminal law and tort law at the same time and find yourself writing that intention means this in one area and intention means something else in another area. And it might happen to be timing that forces you to make that comparison. I'd hope that if you learn nothing else from today's seminar, that there are these wonderful and difficult questions that are worth asking, if only because all the best we can do is bring some minimum amount of understanding to difficult areas. And we might ultimately decide we can't bring it across all the possible areas we could. But if you think really hard, you might increase it. And that's the minimum I'm asking for my career as an academic, to try and bring that little bit more clarity and certainty to very difficult questions. I'm now going to hand you over to someone who's brought a lot of clarity and certainty to the areas that he's worked on, Professor John Murphy.
Thank you very much for that overly kind introduction, Matt, and thanks to all of the people at Notre Dame who have made it possible for me to be part of this webinar today, and greetings to all of you who are participants in this event. I only have 10 minutes, and I'm happy about that, because even if I had twice the time that Matt had, I probably wouldn't be able to say anything nearly so erudite as he's managed to say in just that small amount of time. So I shall use my 10 minutes with some sense of relief, as an excuse, if you will, to say nothing more than, to give you nothing more than a whistle-stop tour of the economic torts and the fault elements that we find at work within them. Now, just a few prefatory words before I get down to the substantive issue of the fault elements that we find at work in the economic torts, because I'm conscious of the fact that very few law schools actually teach the economic torts, and it's possible that a number of these actions, perhaps even all of them, are unknown territory to you. You're not terribly familiar with them. I will make some small descriptions of some of these torts as I get onto the substantive material. But those prefatory remarks. First of all, just to explain that these torts are called the economic torts because historically they have been invoked overwhelmingly to protect trade or business interests. There's nothing more mysterious about their name than that. I don't think that that's what they're confined to, but that's another issue. I have elected to talk about the economic torts because, as Matt's alluded to in his talk, this is an area of tort law in which fault elements are very much to the fore. They're very much at work. There's only one economic tort, that of passing off, in which there is strict liability. All of the rest of them insist upon some sort of fault element as an ingredient of liability. So hopefully my talking about these torts will dovetail nicely with the material that Matt has covered. You'll notice that I've talked about fault elements, and I might even use the phrase mens rea requirements. And I've done this quite deliberately because I'm keeping away from talking about these as being intentional torts. And if you'd listen closely to Matt, you will perhaps have detected the reason why. It's because these torts are animated by a number of different fault concepts. Intention is certainly to the fore in some of these torts, but it's not the only idea play. Some of them are animated by the idea of malice, and recklessness too plays a part in the economic torts, depending on how widely you draw the boundary of the economic torts. The scholars disagree about just how many there are and which ones qualify. Having said that there are three different mental elements, mens rea requirements, that are found at work within the economic torts, it would equally be too simplistic simply to say that within the economic torts, there are torts that are triggered by intentional wrongdoing, or by reckless wrongdoing, or by malice. And the reason for that, and this is where I dovetail even more with what Matt had to say, is because these concepts are themselves very slippery, very fluid, and mean different things in different torts. So with that, let me make a start with the first of them. And I did send around an email with a sheet. I'm not putting slides up, but it would be the second sheet now. There are 5 torts in which intention operates as an ingredient of liability, but it means something different among the various torts. In one context, intention relates to the breach of a contract. One need intend conduct on the part of a third party, but not a particularly harmful outcome for the plaintiff. So inducing breaching contract in its bare essentials involves a defendant doing something to persuade a third party to break a contract with a plaintiff, and the plaintiff then elects to sue the defendant. And all that is required is that the defendant should intend that the third party act in breach of that contract. It is immaterial whether the defendant intended to cause loss to the plaintiff. There's a very famous case involving a bunch of miners who were persuaded to go out on strike, and the defendant said, well, look, the miners going on strike is likely to push up the price of coal because there'll be a shortage of coal, in which case the employers are likely to gain from the increase in the price of coal. So you can't say that I'm intending to cause you loss. Court says, no, it doesn't really matter. All that is necessary is that the intention should latch onto the act of the third party. Then there are two other economic torts, one known by the name in this country at least as causing loss by unlawful means, and another tort known as intimidation that exists in a two-party form, I still think, in which the intention must attach to the particular deleterious outcome. It must attach to loss that has been caused, and not just loss that has been caused, but loss that has been specifically envisaged of a particular kind. We know this because in the leading case it was said that intention to cause loss is needed as an end in itself or as a means to an end. Seems to me that something can only be an end in itself if you specifically envisage that particular kind of loss, or as a means to an end if you have some form of crystal clear notion of the loss that you want to visit upon an individual to some other ulterior purpose. I don't have time now to say why I think it's exactly the same test of intention in intimidation. In unlawful means conspiracy, it is, again chiming with what Matt said, almost impossible to say exactly what the test of intention is. What we do know is that the leading case of Total Network tells us that it is a tort that requires intention, and we know also that it's intention that pertains to the loss that is visited upon the plaintiff. But the final thing that we know is that the court in that case said it's not quite the same test of intention as we find in operation in the unlawful means tort, causing loss by unlawful means. It's probably a narrower test based on targeted harm, and probably therefore chimes with the idea of causing loss which is an end in itself but not a means to an end. But it's not absolutely clear from the leading case. Then in deceit, we're back to intention relating to conduct. What must be intended is that the plaintiff should detrimentally rely upon the words, the misrepresentation uttered to him or her by the defendant. And there is no requirement that the specific harm that is caused should be envisaged by the defendant. So if you go back to what was said in OBG, the leading case on causing loss by unlawful means, the court said that one is not liable for loss which is neither a desired end nor a means of attaining it. That's not true with deceit. All that one need intend is that the plaintiff should act detrimentally, and it does not matter what harm ensues as long as it is directly caused harm. Then we move to the other economic torts in which malice seems to be a key ingredient. Not intention, but malice. And two torts in particular are worth mentioning in the context of malice understood as a bad motive or ill will or spite. And they're lawful means conspiracy and injurious falsehood, sometimes called malicious falsehood. And the idea, again, it's really just repeating what Matt said, is that the idea is that the defendants, in the context of lawful means conspiracy, should have acted with a preponderant bad motive. The emphasis is upon motive. And the same is true in the context of motive malice, the motive malice version of injurious falsehood. But there's another version of injurious falsehood, and this is the last one that I'll talk about, and that's known as deceit malice. And for the purposes of deceit malice, we find that recklessness as to the truth of the statement that is made is enough to trigger liability. Just to say a little bit about injurious falsehood, all that is required is that the defendant should say something false about a trader or their goods or their business, which causes customers to divert their custom to other people's products. And it's enough that you say something or publish something reckless as to the truth of that thing, but it is utterly immaterial that you intended harm or that you be reckless as to that harm. How do we know that? Because of what has been said in English cases, but most amusingly because of the facts of one Canadian case, the Manitoba Free Press case, in which a newspaper published an obvious joke story about a haunted house, about various ghosts and poltergeists getting up to all sorts of things. The sale of the house fell through, and the plaintiff was able successfully to sue for injurious falsehood. I fear my 10 minutes are up. I'll hand over to Marta.
I'm just going to share my screen now. Can everybody see it all right? Okay. So good afternoon, everybody, and thank you very much, Professor Burset, for the kind presentation. Well, I must first of all express my gratitude to the Notre Dame Law School for the invitation to take part in this panel, and to Professor Dyson for thinking I could contribute something interesting to it. I'm frankly overwhelmed to be sharing this virtual table with two professors I admire as much as Professors Dyson and Murphy. In fact, it's taken me some time to, if I may, psych myself up to the fact that I'm actually here with my sketchy English and my unfinished PhD. I very much hope not to disappoint you, especially after the brilliant presentations that have preceded this. There is really not much one can say in the 10 minutes I have, and I wouldn't like to exceed either your lunchtime or your patience. So I'm going to try very hard to stick to them. Fortunately for me, Professors Dyson and Murphy have pretty much covered everything I would be able to say about fault in common law jurisdictions, and I wouldn't dare to add anything to their presentations. So I thought the most useful way for me to close this panel would be to just offer a quick comparative view of the way we approach issues of fault in civil law jurisdictions following the Germanic model, which include, among others, German, Italian, and Spanish law. And taking into account that this really needs to be a quick overview, I have prepared a very simple diagram in order to keep things schematic. In what follows, I will hence limit myself to the presentation of the diagram, and will of course be happy to answer any questions you may have about it, or to further delve into the aspects you may consider more interesting. So this is my diagram, and as I said, I'm not going to add anything about the left-hand column of the diagram to what my colleagues have said. My only aim is to take the common law classification of fault types as a comparative standpoint in order to explain the right-hand column of the diagram. And I would just like to focus on 5 salient features that can be drawn from the comparison. First of all, you can see from the diagram that both systems are alike as regards the scope of application of tort law across all the spectrum of fault types. Both in civil and in common law jurisdictions, liability in tort can attach to intentional, reckless, or negligent conduct, or indeed be altogether independent from fault. However, the scope of criminal law is different in both systems. Whereas in common law jurisdictions, criminal liability may be strict and also attached to merely objective negligence conduct, subjective gross negligence is the threshold for criminal liability in civil law systems. Now, I will come back to the difference between objective and subjective negligence in a minute. For now, I just want to draw your attention to the general fact that the common law crime is, as Professor Dyson says, formally broader than civil law crime. And there is, of course, as Professor Dyson has also remarked, an easy explanation for this. In our systems, the so-called administrative criminal law, the Unwidrigkeitsrecht in Germany, where less stringent fault requirements apply, occupies a space that is rather covered by criminal law in common law systems. Now, the second remarkable aspect that I would like to point out is that both the upper and the lower part of the diagram are equivalent in common law and civil law jurisdictions. Our dolus directus is the equivalent of both purpose or direct intent, that would be our first degree dolus directus, and knowledge or oblique intent, that would be our second degree dolus directus. On the other hand, strict liability means basically the same in common law and civil law jurisdictions. Briefly put, liability attaching to conduct that is reasonable even from the objective point of view. Thirdly, if we leave strict liability aside for a moment, the main difference between both systems is that the threefold common law classification of fault kinds, intent, reckless, negligence, is not matched by civil law jurisdictions, whose basic distinction is between dolus on the one hand and negligence on the other. In other words, we do not have a recklessness category as such, and nor do we have a perfect functional equivalent for it. Indeed, common law recklessness covers both cases of our dolus eventualis and of our conscious gross negligence. Both dolus eventualis and conscious gross negligence require that the defendant has actually foreseen a substantial risk that the damage will occur, not merely that this risk be foreseeable. Where the boundary between both fault types must be set is, however, still heavily disputed, whereas some authors argue that the difference hinges upon the magnitude of the risk foreseen by the defendant. Others, and this is the scholars that Professor Dyson was referring to, only support a finding of dolus eventualis in cases where the defendant has displayed a particular internal attitude of indifference towards the risk. Now, the fourth aspect that I would like to focus on concerns negligent criminal offenses. In the civil law, criminal negligence is necessarily subjective. Now, let me explain for a moment what I mean by this, because this is not the sense in which you normally use the adjective subjective, as referred, for instance, to Cunningham as opposed to culpable recklessness. For us, subjective negligence does not require that the defendant be actually aware of the risk. In other words, subjective negligence doesn't need to be conscious. It can also be unconscious. What subjective means in this context is that for criminal negligence to be established, it is not enough that the defendant has behaved unreasonably. She must furthermore have been personally able to comply with the standard of care. Hence, a defendant that is too young or old or slow-witted, etc., to behave as a reasonable person would do, will never be criminally liable. We take this to be an implication of the criminal principle of culpability, whereas in tort law, for instance, objective negligence, that is, regardless of the defendant's personal capacity to abide by normal standards, will normally do. As far as I'm concerned, however, in the common law, criminal liability can also attach to objective negligence. Now, the fifth and final remark I would like to make concerns the issue, which of these two systems is more punitive? Well, on a first glance, the answer to this question seems to be fairly obvious. The criminal scope of the common law is formally much broader in that it includes both objective negligence and strict liability offenses. On the other hand, however, it must be taken into account that, perhaps with the exception of manslaughter, in the common law, no serious forms of punishment attach to offences that are less than reckless. In civil law systems, criminal liability for unconscious gross negligence, which is akin to your courtware recklessness, is much more widespread. It includes not only homicide, but also most non-fatal offenses against the person, serious forms of property damage, and even some white-collar crimes like criminal bankruptcy. In fact, we don't even take conscious negligence to be necessarily more culpable than unconscious negligence, all other things being equal, although this is heavily disputed. In this regard, I think it might be said that from a substantive point of view, our criminal law is broader in scope than yours. It all, in the end, hinges on the perspective adopted, I guess. Well, that was all I was going to say. Thank you very much for your attention. And I will now hand over to our moderator, Professor Burset.
Thank you to all of our panelists for 3 fantastic presentations. The Q&A is now open, so if you will use the Q&A function to send in your questions, I will then moderate and ask them to the panelists. But first, while we're waiting for that, I had a question actually especially for Professor Dyson and Ms. Pantaleón Díaz, although Professor Murphy can also jump in here. Professor Dyson, you talked a bit about the procedural context through which fault emerged, and sort of the important changes around 1850 or so and going on after that. So, you know, my own interests are in procedure, and I'd love for you to elaborate on that if you could, because it seems like there's been, to some extent, a fair amount of convergence functionally between the civil and the common law systems. Of course, the wonderful chart that Marta had showed the sort of different line drawings at different places, but the top and the bottom are basically the same, even though in civil law systems there is essentially generally no civil jury. In common law systems, of course, it's been de facto abolished, but it still looms very large as a conceptual presence. And so I'm wondering, to what extent does the erosion of the civil jury in the common law system change the way that people are thinking, not just the ability of, change the way that people are thinking about establishing fault. And then on the civil law side, does the fact that the jury plays such a role make comparisons to the common law system less valuable for civilians because the fact finder is just such a different background?
Wow, so there's quite a lot there. I think there's a few points I could draw out, and there are many, as always, that Marta could probably make better, and the same would be said for John. So I'll just limit myself slightly. So the major change in 1852, 1854, 1873 to 75 were about the way that tort actions were brought. The forms of action were removed, and it ceased to be necessary to have certain clothing for your tort action. You didn't have to claim that you were bringing a tort in X or Y. You could essentially just plead the facts. Now, while they have still lingered significantly in the way tort law has developed, that shifted us from being quite as procedural to being slightly less procedural. And the nature of the tort law doctrines started to be worked on more. This is somewhat simplified, but that's one story. Another part of this is who could give evidence. And certain issues became crystallized in different ways, and therefore different evidence about them was being brought to drive that crystallization, because defendants could give evidence, defendants started to have the right to have counsel. At the same time, what I didn't mention was that summary jurisdiction grew significantly, which was the growth of magistrates' courts and decisions basically without the full protections of a trial by indictment in front of a jury. Now, today it's about 95% of cases don't feature a criminal jury, but that's not because of plea bargaining, which we don't have in the same way as happens in the US. There isn't any right that you have to negotiate, and you're not asked to negotiate about a charge. There can be what we call carving, which is sometimes when a prosecution counsel and defense counsel might get together to try to work out what is going to work best, but it's not exactly a plea bargain in the same way. Whereas in civil law, we largely got rid of juries at the end of the 19th century. There was a formal another step in the 1930s, which marked a really big change. So we haven't really had significant civil juries since the 1930s. They did occasionally appear in defamation cases until 2013. But even when we did have them, again, for most of that period, they didn't decide quantum, they decided only liability. So they didn't decide on exactly how much. So what does this all mean for fault? Well, there's a few things. One, I've noticed that there is two classes of criminal barrister in England. There's a class who really do specialize in working with juries, and there's a class who specialize, or maybe even just magistrates, and there's a class who work on appellate jurisdictions. So people who appear before the Court of Appeal and the Supreme Court now tend to have very different styles and experience. They have to behave in a very different manner to persuade these senior judges than to persuade juries. And that's really interesting, different kinds of arguments. And I think we can see that in the development of tort law. Arguments became far more nuanced and complicated when they didn't have to be given to lay people who were just coming in for that period. And that filtered down into the nature of the kinds of fault arguments that would be reasoned. It wouldn't be possible, I don't think, in tort law to use intention in great detail for significant factual problems and not have a better definition than criminal law uses. Criminal law doesn't need to, because it requires a jury to substantiate a lot of its meaning. Now, we do this not only in intention, less so in recklessness, we do it in gross negligence. In England, that means negligence that was so gross because of the nature of a serious risk of death that it should be criminal, which is not exactly a great definition. And it's only applied in gross negligence manslaughter as an offense anyway. So there's some serious gaps in law that are substantiated by a jury, which is another major difference with the civilian tradition, where the substantiation, at least in the German version of criminal law, happens essentially through doctrine, whereas for us, it doesn't happen significantly through doctrine. Now, a number of these things are in shift, but basically procedural consequences and how the questions get asked has been a really big part of how English law has developed in that period. Sorry, that was quite a long answer, but over to Marta.
No.
I don't know if Professor Murphy wants to add something first.
I wouldn't want to add to that because I think there are other people waiting with questions, and it was a very comprehensive answer.
Okay, then I'll just add from my perspective. I'm not at all an expert in procedural law. But I would say procedure is not the greatest challenge for comparison between the common and the civil law in tort and crime. I would say the greatest challenges are actually substantial. For tort, I would say the greatest one is the contrast between a general clause system like the Spanish one or the French one with a system of particular torts like that exists in the common law, because some torts, for instance, most economic torts or nuisance would not be a part of civil law, tort law, but of property, unjust enrichment, unfair competition, and so on. So that is really a challenge, because one really has to look into different areas of law in order to grasp what tort law in the common law is actually about. And for crime, I'd say the greatest challenge is that in Germanic-like systems, the French is not like that, but German, Spanish law are, the offense structure is actually altogether different. So we don't have this difference between actus reus, mens rea defenses. We would have like a five-fold sequence of elements, and some actus reus elements fit some of them, some mens rea elements would be in one part of the set. So I wouldn't like to expand on this because it would take us too long, but I have never encountered so many procedural differences in comparison, although these differences exist. But my greatest challenges have been the substantial ones.
Yeah, thanks both. We're just about out of time, but if the panelists have time for one more question. This is coming from Sarah Wetzel, who asks, I noticed that you mentioned judges in the UK sometimes put on a different hat to resolve a criminal law case versus a civil law one. So how would this work with two different definitions of intention? For instance, would they have to reevaluate the role of intention in the crime to match with the tort law definition if you're using now the tort law based on restitution? Or do you still treat the crime as criminal but apply a civil penalty?
I might start, though others might join in. So I tried to say, and I might have misspoke, that exactly swapping hats is a slightly more continental thing to do, because you'll use a civil law set of doctrines inside a criminal court. So the judge almost becomes a civil judge for a brief moment. Whereas the common law version of this is the criminal judge acts as a criminal judge and makes a criminal compensation order, or commonly in the US, restitution order. And in which case, using the semi-hybrid, essentially a criminal order model, you don't have to use a different version of intention. So you're not making that comparison, which partly explains why we don't do it so much. Because you just award it if there's been a loss caused by a crime. But the continental version would be, well, it would depend. And actually, interestingly, that is the very reason why the French at the start of the 20th century decided that every criminal fault would automatically be a civil fault. Because they said, well, look, we're dealing with these cases under a partie civile system where the civil party is involved in the prosecution to some minimal extent. So we need to know what the difference between the two is. So that very procedural connection forced an answer to the exact kind of question you're doing, and they decided they would be the same. They've since ameliorated the rule ever so slightly, but that was what they did.
All right. Thank you all very much. Does anybody else want to add anything to that?
Nope.
All right. We are unfortunately out of time. Thank you to the three panelists. This was a fantastic start to our Global Spotlight lecture series. I hope that our audience members will join us for future events, and have a good afternoon.
Thank you.
Good afternoon. Thank you very much.
Yo.